Next is number 12, Attorney Grievance Commission versus Robbins. Counsel, whenever you're ready.
If I may approach that with my tablet computer here, try not to refer to it too much or get in the way. There won't be any loud keystrokes. I know that will also be an issue sometimes. What I'd like to do is focus on the primary issue that we are asking the court to address primarily today with regards to Mr. Robbins and the petitioner's case involving the allegations that are presented, which are a unique set of issues, frankly, outside of the specific subject of matter, specifics of the three clients that the petitioner is questioning the behavior with regard to the respondent as counsel. Specifically, and I'll break it down to about 3 or 4 categories. There is a due process related issue that we are raising very strenuously that impacts adversely and taints the entire process, specifically the ability to get a fair trial. And when I say due process, I don't throw that out as a catch-all, minor, miscellaneous argument as, you know, like a catch-all like we would in the hearsay exception rule concept. This is a fundamental issue that goes to both procedural and substantive rights for my client. And what do I mean by that? Well, I say that, and I think we briefed this a little bit, but I want to make sure the court has an opportunity to vet any questions it may have with regard to these issues as a part of this argument today. First and foremost is that my client, when presented with these allegations of mishandling and abuse of a relationship with 3 clients based on the argument, theoretically without proof, that these were elderly or disadvantaged or disabled clients, that he retained a firm, Newsonoff and Smith, which is a respected firm in Baltimore City. He had looked it up. They did a lot of defense work in the area for matters for clients before the Attorney Grievance Commission. He met with both of the partners. One of them actually came to his house in the early part of the inception at 9 o'clock at night. My client lives in Potomac. This lawyer came a considerable distance. They've met for hours. Representations were made. Statements were made as outlined in the various pleadings that have been filed and the exceptions that we filed in September. Specifically, the issue of at the time that this matter was that my client was seeking counsel, Newsonoff and Smith, unbeknownst to my client, was overflow or conflict counsel for the petitioner. Okay, so this firm is on both sides of the case. Okay, as far as the relationship with the client and the petitioner, Attorney Grievance Commission, they don't dispute that. Petitioner does not dispute that they were involved with and referred several matters to the firm of Newsonoff and Smith concurrent with and overlapping the time period that my client is seeking their assistance and asking for representation. Number one, the Attorney Grievance Commission never disclosed that once they saw the Newsonoff and Smith name entered into the case on behalf of my client. It's our position that when you know or should know with reasonable protocols in place that identify conflicts, that if you're become aware that the new lawyer entering the appearance may have a conflict, you have an obligation at that point to notify not only the court but also the opposing party that, hey, that law firm we have a prior relationship with or a concurrent relationship as it relates to this case, and there may be a problem, okay? That conversation never took place on the part of the Attorney Grievance Commission, the petitioner in this case. Furthermore, Newsonoff and Smith itself, I believe, actually sent one of its employees to work for the Attorney Grievance Commission while this was going on. So there is it's a little strong word, but I don't know what other better word to describe it, incestuous relationship going on between Newsonoff and Smith and the petitioner in this case, the Attorney Grievance Commission. Now, Ms. Lawless, initially, when I asked about this, when I found out about this, I asked her, she says, no, that's not true, okay? And that's all reflected in the pleadings and the transcript down below, denied it, okay? But then I just wasn't happy with that answer. I kept digging, okay? Went to my client and said, this is what they're saying. And at that point, then, I got the affidavit in question that is a predicate for not only for the motion that I filed at the Montgomery County Circuit Court level, but also here, both of those were denied. Judge Storm was clear that as it relates to the issues I was raising, the due process arguments, his hands were tied, okay? He did not feel he had the jurisdiction to address those issues. His responsibility per this court was simply to make findings of fact and conclusions of law premised on the actual petition charges, the remedies and the disciplinary action that were being asked for. In other words, staying within the four corners was filed by the petitioner to the Court of Appeals. He had to stay within that confines. He was not authorized, and the transcript is clear on that, when I raised these issues several times with Judge Storm in different contexts, that his hands were tied. And I acknowledged that. I knew his hands were tied, and I appreciated and thanked him for his consideration, even though he denied my motions, because I don't think he had a choice. His hands were tied, at least as I understand.
Mr. Kane,
yes.
You submitted Exhibit 2 with the documents that we received most recently that has a flow chart on it. It's a pretty elaborate flow chart. Can you use this exhibit to point what the specific conflict is with Newsonoff and Smith?
All right. I'll have to, if I may, go to count my clients. Thank you. And I apologize again for the late filing of this. It was late last night, I think, when this got submitted, and I apologize to my colleagues for that. I'm sure they were not appreciative of getting at the late hours. But unfortunately, in the electronic filing process that we're in today, I get things from the bankruptcy court at 12:02 in the morning. That's when they dump all their stuff out. I got just recently a notification from the Maryland Workers' Comp Commission that the issues I've mailed to them 2 weeks ago was filed, and that notice came to me at 11 o'clock at night. So unfortunately, this is where we're heading in this world of, MDEC and everything else. It's 24 hours. That's an advantage, arguably. It's also a challenge, because that means you got to be in your A game 24/7, 7 days a week. You're getting stuff and you're being charged with notice. But so I apologize again for the loud late night filing on that. If we take a look at, let's see where apologize, I'm going through this to see exactly what the connection fits in. At the very bottom, in the center section, there's Newsonoff and Smith, Your Honor, and there's Jeffrey Newsonoff and Norman Smith. Again, my client, Mr. Robbins, met with each of them individually and talked about the case, was reassured in the early stages that my client had a strong case on the merits. He was not told that there were substantial problems with the case. Mr. Robbins was reassured both at the first meeting at his home at 9 o'clock at night, and then later when my client met with Nusinoff and Smith at their office in Baltimore City, that this was a strong case. It was a good case. They had a strategy, a plan of action that was in place. What ended up happening is directly opposite of that entire strategy by Nusinoff and Smith. What I wanted to make the point is that for all of you to appreciate is that when this case was moving along, and this relationship with Nusinoff and Smith and my client transcended over a year as far as a relationship, there was plenty of time and opportunity if Nusinoff and Smith vetted properly, or frankly for the petitioner to bring to the attention of either Mr. Robbins or Nusinoff and Smith the fact that there was a possible conflict here that needs to at least have a discussion about it. That never took place. I'm not even sure it's a waivable conflict because it's a conflict between two parties who are in active controversy with each other. I don't think that's even waivable, to be perfectly honest. But that's another issue that we have to get into at a later point in time, which is why, just to make sure I make this point before I get too far into the other issues, that these due process issues need to be addressed in order to be assured that the process by which, when we send a lawyer through the disciplinary process at the circuit court level on an expedited process, as Your Honor knows, you've got about 4 months.
I'm sorry, Mr. Kane. I
Yes.
want to go back to Judge Getty's question about
Yes.
this Exhibit 2. What is this chart?
This is a flow chart just showing all the various players and connections that at different times each of them had with each other. The point of this exhibit is to try and demonstrate this is a very complicated interrelationship between what is essentially about 12.5 either entities or individuals. This isn't just simply one individual and one lawyer and dealing with defense on a claim by the Attorney Grievance Commission. You've got a number of various complicated relationships and various levels of communication that took place, including, frankly, as up in the upper right-hand corner, this court. Okay, when I first got into this case, just so Your Honors are aware, the prior counsel, when they walked out on Mr. Robbins and withdrew a week or so before trial, all right, Judge Storm let them out. I would not have let them out if I were Judge Storm. You're in the case up to a week before trial, you're in, okay? I don't know what the issue was that they had but my experience has been in 35 years of practice, trial judges don't let trial counsel out on that short a notice prior to trial. It's too disruptive. It's not fair to one or the counsel or the parties. Okay, so notwithstanding that, they let him out. Okay, Mr. Robbins comes to me a week later, so he's trying to find counsel, and he says, "Can you represent me?" I'm a sole practitioner. I don't have any staff. I don't have a law clerk, secretary, nothing. Everything I do is me. Okay, which is why I'm up till often 1 o'clock in the morning and then getting up at 5:30 before I head out the door wherever my day starts me. I said no. I said, you've got to find somebody else. You've got like 500,000 pages in this case involving multiple clients, an ongoing history. It's not fair to my other clients to take this case on. It's not fair to you. Somebody's going to get the short stick here. Not happy about this. He comes back to me a week later and says, I tried. Can't find anybody. So now we got a man who is essentially in a pro se status in a very complicated case. And like your prior counsel, I have a heart. You know, I care about people. And my representation goes back to, with sidetrack for a second, when I was finished my first year of law school at Georgetown, I was very unhappy with the legal profession. I didn't like a lot of the stuff I saw amongst my colleagues. I had an opportunity to spend the third week in June of '81, a whole day with Mother Teresa. She changed my entire perspective on my life in general and as to what I'm going to do with my legal career. Her philosophy was, don't worry about those other people. Worry about are you doing what God wants you to do. And that's the philosophy, that's the mentality I still today practice law with. And so if I see a client that's hurting and nobody else is helping, I'm not going to walk away. Okay, so at a great deal of expense and sacrifice, I picked up the mantle and represented this man. But when I filed the motion and entered my appearance, I said it very clear, and I had a very clear conversation with the petitioner beforehand. I've got a bunch of motions I'm filing because there's discovery that's closed, that hasn't been done, hasn't been answered timely or properly. The scheduling order is already, I'm behind on the scheduling order. I mean, there's a whole bunch of things that I got into. And I got some relief, not others. I immediately filed a motion for extension of time for the trial date to bump it out further. And your honors granted us, I think, another 4 months, but then because of the scheduling, the way it was set up with Judge Storm, it basically got pushed into March. So we were stuck with a March time period. So instead of the 4 months that I hoped for, that you folks had given me, I got 2 months. So that's all I got. So, exhibits haven't been assembled yet. I haven't gone through any of the documents. I'm frankly learning the case on the eve of trial. Okay, not a very comfortable position to be in as counsel in a complicated case like this. I'm doing my best. I'm trying, but it's not easy. Okay, and what frustrates me is if this case had just been on the merits of these 3 clients with all the documents, that would have been one thing. But a whole hornet's nest of new issues, due process issues came up. Prior counsel, Newsonoff and Smith, when they got out of the case, they never sent their file to my client. And when I asked for it, when I entered my appearance, they said, well, he's got everything. I went back to my client and said, they sent you everything. I said, no, he didn't. So I went back to him again. I said, where are your file notes? There's got to be handwritten notes that every lawyer makes to a file about conversations, documenting. Oh, we threw those out. What? You threw them out? I mean, you got to be kidding me. That's a client property, the file, and you threw it out? That's outrageous, okay? So I've got that issue to deal with. Then I got this unbeknownst, not documented, because I don't have anything that documents anything one way or the other, agreement to not answer discovery formally. When they finally submitted discovery responses, the petitioner did to the defense in the middle of December. Now, discovery closed December 1, okay? These discovery requests were significantly a number of months earlier, like September, October time period. So well more than the 30 days had run. What I heard feedback from both petitioner and from Newsonoff and Smith was, oh, we had this agreement that we weren't going to answer each other's discovery in writing. We were just going to informally exchange stuff. Okay, but you're out of the case. Now you see the mess you've created for me? This is a disaster. I mean, I don't have any confirmation of anything. Yeah, interrogatory answers enable you to narrow down the issues, identify the documents, the exhibits, the persons involved. That helps you kind of figure out what the heck's going on with this case. I'm running blind, okay? Bad enough I'm getting into this case at the last minute, given the challenge and the documents, but now I still don't have the benefit of discovery that I can rely on, that I can at least hang my hat and say, okay, this case is not about this, or it is about this, okay? I'm at a significant disadvantage, So, and then I find out that there were depositions taken in which the witness refused to produce documents, okay? I don't have any notations of that occurring in any of what I have, but I find out about it talking to the witnesses, and specifically Mr. Edwards, one of the witnesses that the petitioner had as a part of their case. And I'm not throwing any dispersions on Mr. Edwards. He's a fine lawyer. No, that's not the issue here that I'm raising. The point is, when they took Mr. Edwards' deposition in the discovery process, Newsonoff and Smith, the counsel that the petitioner used in conflict cases, they were aware at the time that the Edwards and Edwards law firm were asserting a privilege with regard to a number of documents, about 130, 140 pages worth of PDF documents, okay? No priv log, no outline identifying what those documents are. So now I get the documents. Edwards' law firm finally decides, you know what, we're going to produce them now regardless. I get them a week before trial, okay? Discovery closed December 1. I get them a week before trial. That's just not fair. That's not due process. That's trial by ambush. The petitioner's witness is sending me the things that they wouldn't give to my client's prior counsel during the discovery period. Now they get dumped on my desk a week before trial as an email attachment, a bunch of PDFs, documents. And I called up Mr. Edwards. I said, this isn't fair. This is not right. And I complained. It's the only thing I can do. Went on deaf ears, okay? I filed motions continually, several of them, 2 or 3 of them, about these discovery deficiencies, the missing file, the conflict, all of this, Judge Storm. Judge Storm was fully aware of all of this. The transcript is replete with a number of instances of documenting this. Again, as I said before, Judge Storm felt that he could not do anything because his hand was to be tied, and he was like a magistrate, where he just makes findings of fact, including his law, on the issues that are in front of him. So that's what, there's a lot of other things. We've got, they're outlined in the various exceptions that we filed to Judge Storm's findings. And Judge Storm is a nice judge, okay? He's a nice guy, okay? And I have a great deal of respect for Judge Storm. I know a lot of the judges on that Montgomery County Circuit Court bench. That's probably the bench that I practiced the most in front of in my 35 years. But this was not a fair trial. In my 35 years, I've got a right to say that gives me a little bit of expertise as a trial lawyer and say this just wasn't fair. Okay, it wasn't fair to counsel, and it wasn't fair to the client. And it was just patently, something needed to be done different than what happened here. This was just outrageous. I think it shocks the conscience, to be perfectly honest. I think it's patently so unfair and draining, okay, of my time and my client's stress levels. He had health issues. I had health issues during this thing. I was running 4 hours sleep routinely, Monday through Friday nights. It was just crazy. I mean, we were just working like we could to dig out and be prepared properly, and we were just always a day late and a dollar short because of something came up in the case we didn't know anything about. And then we got a trial date that got bumped because of the snow isolation. We had a trial date originally in March. They got bumped into, I think, April or May. So my point is, what I'm asking the court to do is to take a look at the due process arguments, carefully examine, and say, do these issues, if true, giving the benefit of the doubt to the respondent, if true, would they taint the fairness of the trial on the merits with regard to the disciplinary process? If the answer is yes, then my suggestion is, and my request, is that you stay these proceedings and order an examination into these due process issues to find out what is going on. Because this is a problem. This is not fair. You don't take a man's livelihood away to practice law, plus he's got certifications as a CPA and a financial planner. Those are all going to be in jeopardy because it'll go like dominoes right through when he's got to tell the other two whatever this court does. And this man lives by himself. So it's just not fair to basically end his life functionally, effectively as far as a professional standpoint because of a tainted trial process that occurred as I've described in the various motions and pleadings that I filed. I even provided to your honors a copy of the U.S. District Court complaint that I did not draft. My client did. I say that in reference to the prior case. But I thought when the client filed it and sent it to me, I said, you know what? That's a pretty good summary of some of the issues you're complaining about. So let me attach that as the third exhibit to my late filing of yesterday. And so I decided if you choose to pay attention to it, I think it would be helpful. If you don't, because of its late filing, I can understand and appreciate that. But I'd like to really, and again, I'm incorporating all of the arguments on the merits of that we have objections or exceptions to what Judge Storm's findings were that are outlined in the petitions, the document, I should say, the plea that we filed on September 4th. And other than that, I'm just going to defer the rest of my time for rebuttal, if I may.
Okay, well,
I don't know how much more time I have left.
Not much, I don't believe.
Yeah, okay, I'll add that 1 minute onto my 5, so 6 sounds like where I am, because I think I deferred 5, but,
All right.
all right, I'm
Yeah.
trying my best, Your Honor.
That's fine.
I really
Okay.
am. Thank you.
All right, thank you, Mr. Kane.
Thank you.
Ms. Lawless?
Thank you. Lydia Lawless on behalf of petitioner. Mr. Kane's entire presentation is an attempt to divert this court's attention from the fact that Jonathan Robbins is a danger to the public. As found by the hearing judge, Mr. Robbins engaged in a sustained course of misconduct spanning years, during which time he victimized vulnerable individuals and exploited his position of trust to further his personal financial gain. I asked this court to strike the late filed exceptions last night. In 2013, Helen Nutt was 88 years old. In October of that year, she retained the respondent to revise her estate planning documents. Within days of being retained, her son died unexpectedly. Her only living relatives were her adult disabled daughter, who was partially dependent on her for support, her elderly sister who lived in Michigan, and her sister's daughter. At that time, Ms. Nutt had assets valued between $2 and $2.5 million. Approximately 3 weeks after retaining the respondent, Ms. Nutt suffered a fall in her home. She was transported to the hospital, then a rehabilitation facility, and eventually moved to an assisted living facility. Ms. Nutt died in the summer of 2017, having never returned home. Within weeks of being retained, the respondent prepared estate planning documents in which he identified himself as Ms. Nutt's attorney and personal friend. He had known Ms. Nutt for approximately 2 months. The respondent was named power of attorney for her property, agent for her health care decisions, trustee of her revocable trust, personal representative under her will, trustee of her daughter's special needs trust, and co-trustee of 2 personally funded living trusts. The documents were executed by Ms. Nutt while she was in the rehabilitation center. Between 2013 and November of 2015, approximately 25 months, the respondent, acting as trustee, as found by the hearing judge, was actively involved in the management of Ms. Nutt's legal, financial, and personal affairs. A trustee's most fundamental duty is to display loyalty to the interests of the beneficiaries, to the exclusion of all selfish interests and all consideration of the interests of third persons. The respondent failed in his duty. He abused his position of trust and engaged in a sustained course of misconduct and self-dealing. Between October 2013 and November 2015, the period of time at issue for Bar Counsel's investigation, the respondent charged Ms. Nutt more than $340,000. Of the amount billed, the respondent, as trustee of the trust, without accounting or any oversight, paid himself more than $311,000. As found by the hearing judge, the fees charged were grossly disproportionate to the nature of the services being rendered, and the fees were substantially greater than the industry norm. Petitioner's expert witness who testified in this matter, Mr. Frederick Frank, whose testimony the hearing judge accepted, testified that the fees charged and collected by the respondent were 3 to 6 times the industry norm for the services provided. During that 25-month period of time, Ms. Nutt was suffering from aphasia, memory loss, and at some point became unable to write her own checks because she was confused by dates and numbers. The respondent failed and refused during this period of time, despite numerous requests, including written requests, to provide an accounting of his management of Ms. Nutt's trusts. When he did provide information, it was in the form of a 109-page invoice. As found by the hearing judge, the respondent's failure to provide timely invoices and information to Ms. Nutt about the fees and expenses that he was not only charging but collecting deprived her of the ability to make informed decisions about the representation and the disbursements of assets from her trusts. The court found that the invoice, the 109-page invoice, covered such an extensive period of time and was so full of minutia-laden entries that Ms. Nutt's ability to understand what was in the invoice and to confirm or refute any of the individual charges was hindered. The severity of the respondent's misconduct as it relates to Ms. Nutt is magnified by 3 factors. First, Ms. Nutt suffered, by the respondent's own admission, from diminished capacity. She had aphasia and memory problems. She was elderly, she lived in an assisted living facility, and she was absolutely dependent on the respondent to get her bills paid and her medical care provided. Third, the respondent's self-dealing was motivated, as found by the hearing judge, by a desire to achieve personal financial gain to the client's detriment. The hearing judge correctly found that the respondent violated Rules 1.1, 1.3, competence and diligence as it relates to Ms. Nutt, a failure to communicate, and a charging of unreasonable fees in violation of Rule 1.4 and 1.5, self-dealing and a conflict of interest in violation of Rule 1.7, as well as misconduct in violation of Rule 8.4d. The respondent's conduct as it relates to Ms. Nutt is stunning and alone demonstrates that he is unfit to be a member of our bar. The conduct and misconduct found as it relates to the respondent's representation of Annette Torchinsky is similar to some of the misconduct that was demonstrated in his representation of Ms. Nutt in his serving as a trustee. For a 31-month period of time between December 2012 and July 2015, the respondent failed to communicate with Ms. Torchinsky in any fashion about the fees and expenses that he was charging her. As with Ms. Nutt, the respondent failed to provide invoices, which made it virtually impossible for Ms. Torchinsky to know what and how much she was being charged, and enabled the respondent to pay himself for 2 years without accountability, in excess of $50,000. When he did finally provide invoices, as with Ms. Nutt, it was a 71-page invoice. It indicated that he had billed more than $150,000. Important for this court's consideration is the fact that certain discrete tasks were billed and paid for on that invoice on an hour, that certain discrete tasks, or that all tasks were billed and invoiced on a flat fee basis. When Bar Counsel requested an explanation for the respondent as to which charges on that invoice were pursuant to a flat fee agreement versus an hourly agreement, the respondent made knowing and intentional misrepresentations, including misrepresentations under oath, that all services performed for Ms. Torchinsky were on an hourly basis. In addition, to cover up his misconduct as it relates to Ms. Torchinsky, the respondent knowingly and intentionally testified falsely that Ms. Torchinsky specifically stated that she did not want it to see any invoices. As with Ms. Nutt, the respondent preyed on a vulnerable client. Ms. Torchinsky became romantically involved with the respondent about 1.5 years after the formation of the attorney-client relationship. The respondent, as found by the hearing judge, took unfair advantage of his relationship of trust and confidence that he shared with Ms. Torchinsky. The hearing judge correctly found that he violated, again, Rules 1.4 and 1.5, communication and reasonableness of fees, as well as 8.1a in making knowing and intentional misrepresentations of material fact to Bar Counsel, including misrepresentations under oath about the scope and extent of services and the fees associated with those services. And the hearing judge found that those misrepresentations additionally violated Rule 8.4c, and that his conduct as a whole violated Rule 8.4d, and that it brought the legal profession into disrepute. During the same period of time, the respondent was representing Shelba Bossum. During the 3 years that he represented Ms. Bossum, he engaged in the same billing practices as he had with Ms. Nutt and Ms. Torchinsky. He charged Ms. Bossum more than $250,000 in fees and expenses during this 3-year period. As is the case with Ms. Nutt and Ms. Torchinsky, the respondent violated the same communication and charging of unreasonable fees. During the 3 years that he represented Ms. Bossum, not only did he engage in these unreasonable billing and fee practices, he failed to represent her diligently and competently. The hearing judge made specific findings that the respondent failed to timely file a caveat, thereby the statute of limitations passed. Between May 2012 and August 2013, the respondent took no meaningful action to advance Ms. Bossum's case. During that same period of time, he made false statements and misleading statements to Ms. Bossum when she inquired about the status of her case and the lack of action. He then engaged in a sustained course of dishonesty when he made knowing and intentional misrepresentations, as found by the hearing judge, as to the work that he had performed, the status of the case, And most particularly troubling in this case is the respondent's breach of his fiduciary duty as it relates to his use of a power of attorney that was provided by him.
Ms. Lawless, I'm sorry to
Yes.
interrupt. Those findings about the misrepresentations in the Bossom case, do they form the basis of the 8.4C finding?
So we had charged, in petitioner's case, we had charged that they formed the basis of an 8.4C finding. The hearing judge found that not only did they violate Rule 1.4 and that he failed to communicate with her adequately by giving her misleading information, but also that it was a violation of Rule 8.4C in that regard. The facts are undisputed that on June 8th, 2014, the respondent provided a power of attorney, or drafted and provided to Ms. Bossom a power of attorney. This power of attorney provided him with broad authority to take action on her behalf. Ms. Bossom executed that power of attorney. By the respondent's own testimony, she trusted him implicitly. On July 1st, 2014, the respondent used that power of attorney provided to him by Ms. Bossom to execute a third retainer agreement. That third retainer agreement was distinguished from the first two. When Ms. Bossom first retained the respondent, she retained him in her capacity as trustee under what she believed to be her mother's trust, and as personal representative because she believed she would be appointed personal representative of her mother's estate. At no time was she personally liable for her fees to the respondent in those two retainer agreements. In July of 2014, more than a year and a half into the representation, the respondent used a power of attorney to execute a third retainer agreement between himself and Ms. Bossom individually. In that third retainer agreement, Mr. Robbins increased his hourly rate from $350 an hour to $500 per hour and made it retroactive to the effective date or the initial date of the representation in May of 2014. That conduct, petitioner charge, violated Rule 1.8 of the Rules of Professional Conduct. Judge Storm found that it was a violation of Rule 1.7 and a conflict of interest, and our exception is based on the technical distinction between a 1.7 violation and a 1.8 violation, and that it was a business transaction between an attorney and a client. Regardless of whether or not this court sustains that exception, that conduct is abhorrent and a breach of the respondent's fiduciary obligations to Ms. Bossom. The hearing judge correctly found that the respondent engaged in a sustained course of misconduct in the representation of the three clients. The hearing judge correctly found that the respondent made numerous knowing and intentional misrepresentations to bar counsel during the investigation of this matter. Petitioner took two minor exceptions, one as to the 8.1 business transaction with the client as it relates to the Shelba Bossom matter, and the second is an exception to Judge Storm's failure to find that the respondent's knowing and intentional misrepresentations under oath during his statement under oath during bar counsel's investigation constitutes perjury in violation of Rule 8.4b. Unless there are further questions, petitioner will submit on the record before this court the respondent's conduct warrants not only disbarment, but petitioner requests that the respondent be disbarred immediately.
Ms. Lawless, even if we strike the supplemental exceptions filed late, in the respondent's exceptions, they do raise the issue of Newsonoff and Smith and make a remark that they have overflow cases from the Attorney Grievance Commission.
Yes.
Can you address the issue of a potential conflict of interest?
Sure, I'd be
within
happy
the law
to.
firm?
I'd be happy to. First, there are not overflow cases that are provided to Newsonoff and Smith, and there never were. And that has been communicated to Mr. Kane from the outset of his involvement in this matter. The facts of this case and the history of this issue with the conflicts of interest were first raised in the circuit court in a motion filed by Mr. Kane on February 28th. Attached to that motion is an affidavit by Mr. Robbins dated February 16th, 2018. In that affidavit, and particularly, specifically beginning at paragraph 11 of that affidavit, Mr. Robbins acknowledges that Mr. Smith's relationship with the Attorney Grievance Commission was disclosed to him at his initial meeting with Mr. Smith on December 8th, 2016. As this court is aware, pursuant to Maryland Rule 19702H6, the Attorney Grievance Commission is authorized to appoint special counsel where there is a conflict of interest. There are occasions where complaints are filed with our office where there is a conflict either with a member of Bar Counsel's staff or family member, or with the attorney grievance itself, or a partner of someone with the commission. In those instances, special counsel is appointed and the case is removed from our office. So this wasn't a representation, it wasn't a concurrent representation of the Attorney Grievance Commission and a respondent, and certainly not in a substantially related matter. It was something that was completely outside of our office. It's an appointment of special counsel precisely because the commission could not handle it themselves. This has been explained to Mr. Kane on numerous occasions by the respondent's own admission. Mr. Smith disclosed to him that on occasion he had been appointed in this special counsel position over the years. The particular facts of this case were outlined in my response to the February 28th motion for sanctions, and I think motion to dismiss where this is first raised, which was filed on March 5th, 2018. And I'm happy to recite them. As relayed in that motion, in October of 2016, then Bar Counsel Glenn Grossman appointed Mr. Smith as special counsel to investigate and, if necessary, to prosecute 3 complaints filed with the Office of Bar Counsel. The Office of Bar Counsel had a conflict of interest, and Mr. Smith was assigned to serve as independent counsel. The Office of Bar Counsel, its attorneys, investigators, and staff were screened from participation in all aspects and knowledge of that investigation. Mr. Smith advised Mr. Grossman that he had determined that the matters did not present any conflict with any existing clients. The matters were resolved by Mr. Smith in January of 2017. Further state in that responsive motion that the cases assigned to Mr. Smith as special counsel did not involve any common issues of fact or law with the instant disciplinary proceedings, and quite simply, no conflict of interest exists. Any further questions or answers I can provide to you as it relates to that?
After the disclosure by Mr. Smith, was Mr. Robbins, or did Mr. Robbins ever give informed consent?
Judge Watts, I have no knowledge or information as to communications between Mr. Robbins and his former counsel, Mr. Smith. Mr. Smith certainly could have been subpoenaed to testify. He was not. There has been no statement by Mr. Smith as to what, if any, communications he's had with his client. There's an affidavit provided, which I know for a fact is inconsistent with certain facts based on my own communications with Mr. Kane. But quite simply, there was no evidence presented at the hearing level as to any of the, quite frankly, scurrilous allegations against Mr. Smith. And I would note that this allegation that Mr. Smith failed to provide his file to Mr. Robbins is not supported by the record. At trial in this case, there were binders that bore the Newsonoff-Smith logo because it was the file that was returned from Mr. Smith to Mr. Robbins. So I don't know if that answers your question, Your Honor, but I have no personal knowledge, and nor is there anything in the record related to that factual question. And I guess I may as well address the one other issue that has come up in this case that Mr. Kane is focused on, and that's the question about the discovery during the pendency of the disciplinary proceeding in this case. By the time the petition was filed in this matter in May of 2017, Mr. Smith had been involved in the case for, I think it was over 6 months. There were voluminous documents in this case. If my memory serves, it was somewhere between 12 and 15 banker's boxes filled with documents. The scheduling order was entered. Both sides propounded requests for production of documents and interrogatories on the two parties. They were essentially, who are your witnesses? What are they going to testify? What are your documents? and my interrogatories and requests for information from the respondent is what is the mitigation and the evidence related to mitigation. Mr. Smith, Mr. Nusinoff, and I communicated, as counsel should communicate, to develop a discovery plan in this case. And we confirmed with each other that we were both in possession of the same documents. There was this 12 to 15 banker's boxes worth of documents that had been produced by the respondent to me, and the same documents had been produced by the respondent to his counsel. As far as Bar Counsel's investigative file and memoranda associated with any interviews that were done during the investigation, those had previously been provided to the respondent and his counsel through the investigation of this process. At all times, Mr. Smith had access to my file and could have reviewed it and did, in fact, confirm that we had the same information. There was no reason for us to reproduce 15 banker's boxes worth of documents. As it relates to the witnesses in this case, the other discovery for trial, there was no formal response as to who are all the individuals with discoverable information. Instead, what was exchanged was the actual witnesses that petitioner intended to call at trial. Each and every one of those witnesses was deposed by Mr. Smith or Mr. Nusinoff. And at the same time, Mr. Smith and Mr. Nusinoff provided to me the actual names of the witnesses that they intended to call at trial. So discovery was complete by December 1st. There were multiple days of depositions. There was an expert witness, petitioner's expert witness, who was deposed for extended hours. And so when Mr. Smith got out of the case, there was a confirmation email that was sent to Mr. Kane relaying the information and how Mr. Smith and I had resolved and dealt with discovery through the pendency of the case. Mr. Kane continued to refuse to accept that discovery had been completed and completed adequately, and has still to this day not been able to provide evidence of any document or any individual that was not identified during the course of discovery in this case. There were substantial motions. There was a motion to compel discovery that was filed in the circuit court. That motion was denied. There was then a motion for sanctions that was filed in the circuit court. That motion was denied. There was then a motion for sanctions and appropriate relief filed in this court, which was denied on the eve of trial. And I would say that not only was discovery completed, it was completed in an efficient and effective manner as the discovery guidelines in Maryland envision. Thank you.
Thank you, Ms. Lawless. Mr. Kane?
I have at least 5 or 6 minutes, I believe.
No more than 6.
I'm sorry?
No more than 6 minutes.
Correct.
Yes.
And my client would like to address the court with that rebuttal time, if I may.
That's fine.
Okay, thank you.
Mr. Robbins.
May it please the court. My name is Jonathan David Robbins, and I am the respondent in these 3 cases. I prepared a brief statement last night, which I'd like to read to you, and then I'd like to discuss just very briefly some of petitioner's facts. Fairness is a bedrock concept in our laws and our procedure. It is clearly enunciated in the United States Constitution and the Maryland Declaration of Rights, where in the 5th and 14th Amendments and Articles 24 and 26 of the Maryland Declaration of Rights, we are expressly entitled to due process before we can be deprived of life, liberty, or property. The case against me is a study in how failure to abide by the concept of fairness and the requirement for due process can cascade into a massive deprivation of rights. From the initial failure to recognize and inform me of the conflict of interest involving the AGC and my former counsel, to the withholding of potentially exculpatory evidence, the prosecution by the AGC has been infected with lack of due process and basic fairness. The abrupt last-minute withdrawal by my counsel, Nusinoff Smith, after the abysmal failure to properly prepare a defense, set the stage for my current counsel, Eugene Kane, to be hobbled by insufficient time and resources. The denial of the motion to sever the 3 complex complaints with more than 50,000 pages of respondents' documents, coupled with the compression of the hearing to 4 days divided by 2, 1/2 for the respondent and 1/2 for the petitioner, magnified the issue of insufficient time to present my defense. Fairness and due process require dismissal of all charges in these matters. Otherwise, at the very least, a fresh timeline to conduct discovery and prepare for a new panel hearing and possible circuit court hearings should be ordered by the Court of Appeals. I want to just quickly address some very important points that Ms. Lawless has just raised and I take issue with. I dispute that Helen Nutt was as sickly as stated by Ms. Lawless. There was nothing wrong with Ms. Nutt for the first 2 to 3 years of being a resident in an assisted living facility. She signed whatever checks she wanted to sign. She had me sign a number of other checks, which I sought her permission to sign, and she gave to me. She, at the later stages of her life, the very last few months, developed a form of dementia that the assisted living facility declared was 5% of her cognitive abilities, only 5%. She had an aphasia, which was strictly a disconnect between her voice muscles in her mouth and her mind. She simply couldn't utter the words she wanted to utter. She could write clearly and cogently, which she did. I had no problem communicating with her. At all times, I kept her informed of my fees. My fees were taken basically at $500 per hour. My fee structure for the last 1.5 years is $1,000 an hour. I've gotten more clients now than I did before. The simple fact is I'm highly qualified to do the things that I was called upon to do. I did not take trustees' fees. This is a direct, disingenuous statement. What I took were attorney's fees and CPA fees. The conflict with Nusinoff and Smith was never given to me in writing or verbally by either Nusinoff or Mr. Smith. What they did was show me 5 cases that had come in as overflow cases in 1 day and used it as a selling point for me to keep them employed. They failed to depose Mark Fiedler, who was the petitioner's lead investigator. Mr. Fiedler produced an interim and a final report which were laudatory of my abilities and what I had accomplished in the Nutt case.
Mr. Robbins, that will be the last word because your time is exhausted.
Thank you.
Thank you, Mr. Kane, Ms. Lawless. The court will take a brief recess, and please, if the parties in Smith versus Wakefield LLP be present, the council table when we return.